Welcome to DocPro's channel. DocPro has all the documents you need at your fingertips. You've just made an offer to buy a property. Then you realize that another property down the street is selling 10% cheaper. Can you revoke your offer? Well, yes, if you can make and communicate that valid revocation to the offeree in time. This video will provide you with an overview of revocation of offers and conclude with some template letters for termination of an offer. We should start by looking at some key terms. An offer is a proposal of terms by one party based on which he or she is willing to enter into an agreement with another party. An offeror is the party who makes the proposal of terms, and the party to whom the terms are proposed is called the offeree. The offeree must decide whether or not to accept the offer. If he or she accepts that offer, both parties enter into a binding legal contract, which means they must perform the obligations that are stated in the contract's terms. But what is revocation of an offer? Revocation refers to when an offeror takes back or withdraws an offer that's previously made to an offeree. This has the effect of terminating the offer, such that it can no longer be accepted by the offeree. As the offer can no longer be accepted, no enforceable contract can be formed between the two parties. But for valid revocation, it must meet certain conditions and comply with certain rules. Number 1. The revocation must be made by the offeror before acceptance by the offeree. Once again, this is because once that offeree accepts the offer, a binding legal contract is formed, and both parties are subject to obligations. Revocation following the coming into existence of such a contract will constitute a breach of contract, which may render the offeror liable to pay damages. Number 2. The revocation must be communicated to the offeree before acceptance. Such communication doesn't need to be made by the offeror personally. It could also be made by a third party on behalf of the offeror. If an offer is made to the world at large, the offeror should communicate revocation using the same form as that used to communicate the offer. For example, if you posted an offer on a newspaper, you should communicate revocation of that offer on the same newspaper. It is important to note that revocation only becomes effective when the offeree actually receives the communication. If a revocation is communicated by post, for example, the revocation will only become effective when the offeree actually receives the letter of revocation. Number 3. Even if the offeror states that the offer is to remain open for a certain period of time, they can actually still revoke the offer so long as the offeree has not accepted the offer yet. This is generally the case because no consideration or something of value is given by the offeree to this obligation to keep the offer open. Consideration may be given in some cases such as options contracts, where a person's considering entering into a contract but maybe wants to conduct a bit of due diligence before doing so. In this case, the offeror is obliged to keep the offer open for a specified period of time. Overall, an offeror can revoke an offer made to an offeree if these conditions are satisfied. If you want to find out about revoking a unilateral contract offer or other ways to terminate an offer, check out the link to our full blog in the description, which also has customizable templates for your use. Thank you for watching, and feel free to like and subscribe if you found this video helpful.